Speak up, please. Who'd you talk to? Speak up.
Tony Smith.
Say the first one. Hand it to the bailiff.
Right away, this is not a casual check-in when a judge opens with, "You've got 2 cases." That sets the tone this isn't your first rodeo. And when the court asks if you've hired someone, that's about representation, because walking into felony court alone, that's already a risky question for you guys. If you had 2 pending felonies, would you gamble on showing up unprepared?
So did you talk to him or somebody talked to him for you?
Me and my mom was talking.
So are you do you go to MHMR, Spindletop? No? What's that written on here for?
Well, I don't know.
You don't know? So are you working? Why not? You don't know? Where have you been looking?
I went to work. But I had to see my ID. I didn't have ID.
Do you have your ID now? Okay. If I test you this morning, you gonna have anything in your system? Have a seat, let's double check that.
And here's where things get dangerous when a judge says, "Let's double check that." That means trust just ran out in bond conditions. Honesty is currency, and if the court suspects you're bluffing, everything escalates. This is the moment where either he's clean or this whole hearing flips.
No, she won't take the offer, so I just said, yeah,
I'm sorry?
she refused it.
Okay, that's fine, I'll do the plea in just a minute. How old are you, Mr. Jubert?
18.
18 was the last time you smoked dope. What? Last week? What made you think that was a good idea with 2 felonies pending to come be smoking marijuana? You don't know? And you're not working? Obviously, you know that's a violation, number 1, of the law and of your bond conditions, right? Speak up. How do you think you're going to get a job if you're smoking marijuana? What? You quit last week? Wow, congratulations.
18 felonies, and he admits he smoked last week. That's not just a bad answer, that's self-sabotage in real time when you're out on bond. Using drugs isn't just personal, it's a violation, and the judge's question isn't rhetorical, it's credibility testing. Because if you can't follow basic conditions now, why would the court trust you with probation later?
Realize how ridiculous that sounds to say I quit last week? Mr. Jubert, I'm going to find today that obviously that is a violation of your bond conditions in each of your cases. I'm going to raise the bond in each of your case because of that violation. Let me see what they were previously at.
That congratulations wasn't praise, that was courtroom sarcasm. Judges hear every excuse in the book saying, "I quit last week," after testing positive doesn't inspire confidence, it signals damage control. And here's the big picture: credibility, once cracked, is almost impossible to rebuild in front of the bench.
Positive for THC, and so obviously sometime within the last 30 days or so, he's used marijuana, because typically that's how long, which means that he used marijuana after he pled guilty on a felony.
And there it is, consequence raising bond means it just got more expensive to stay out of jail. This is how courts apply pressure, not emotional, not dramatic, financial. Because bond isn't just about release, it's leverage, and when you violate, that leverage tightens.
He pled to an enhanced second degree. I've got pages of criminal history here. And you would think, Mr. Spites, that based on what Ms. Hawkins is telling me about your family situation and your children, that you would be able to figure this out on your own and stay clean so that you didn't, number one, go to prison. I don't even have to accept this plea agreement. I mean, you've got 3 prior convictions, a state jail felony from 2019, from 2019, credit debit card abuse from 2021, and then an unlawful possession of a firearm in 22. None of those cases did you receive probation, which is probably why Ms. Malfino made that offer to try to get you on the right track. And Ms. Hawkins did a great job of getting you a probation offer on your case or cases.
If I may.
Yeah.
Part of the reasoning behind that offer that Ms. Hawkins and I discussed was that jurisdictional type issue that she addressed with the court, and also the fact that there ended up being no restitution that's owed to any individual.
Okay. And I appreciate that argument that Ms. Hawkins made, but it's also important, and I would hope that other judges in other counties would find it just as important. Cause number 25 DCCR 1130, I'm going to raise your bond to $15,000. And I'll go over conditions of both of the bonds in just a minute. And then in cause number 25 DCCR 1131, going to raise your bond in that case also to $15,000. Condition, if you make the bonds in both of those cases, is that you have to have a drug patch on at all times. You have 24 hours from the time you make a bond to get a drug patch put on. A drug patch is something that goes on your arm. Your bondsman can tell you where to get them. You have to have them changed every 2 weeks.
This right here? That's tight supervision. A drug patch doesn't just say yes or no. It tracks levels if those numbers don't drop. The judge assumes continued use, that's science replacing excuses, and here's the real takeaway. This was likely a shot at probation, maybe the first real break instead. One decision made everything harder. Court isn't just about guilt, it's about credibility, and once that slips, the system tightens fast.
If they test positive, then obviously I'll know you're still using marijuana and you haven't actually quit. You're going to go right back into jail with much higher bonds. I would anticipate if you make these bonds quickly that the first patch might be positive, but the patches are going to show me an amount, not just a positive or a negative. So if that amount is not going down, then I'm going to assume also that you're still using. Do you understand? All right, go back with the bailiff.